Okay, so this is the week 6 Zoom for IP law, and what I'm going to do is, as per usual, I will start sharing the screen, and we will go. Looks like Bianca's already had a go at the competition challenge for this week, so that was rather good to see. We will go to the Copyright Act, and then we'll go up here. Alrighty, has anyone had a chance to have a wee look at the problem question this week? That's all right. I came prepared in the contingency that might happen. It's all good. We're all in the throes of assignments, I know. So we'll just go through this in a very friendly fashion, and hopefully it will dust off the cobwebs and remind you of your readings for remedies, infringement and remedies. Okay, so we know our scenario, and this week's questions revolve around obviously infringement and the remedies that the various different people can get. And the first question is, if Nigel and Roy were to sue Fred for passing off or misleading or deceptive conduct, what remedies would they seek and would they succeed? So here we can just do a little bit of revision in terms of the elements for passing off and misleading and deceptive conduct, and then we'll go through the remedies. So firstly, what's the main thing that we need to be proving for the action of passing off? Anyone? Okay, reputation. That is the main thing. And remember, having to prove your reputation, particularly in circumstances like Nigel and Roy find themselves in, can be a real pain, because they haven't been operating for a million years. It doesn't seem like it's that long, although we'll go through the issue of how much time might have elapsed there. But reputation is the thing that you need to devote a fair amount of court time to show that it's a strong enough reputation to sustain the action. I mean, that's what the action is all about, and obviously that's what the court's going to want to see most of. The other difficulty for Nigel and Roy here, I mean, they only want to sue Fred, thankfully enough, who's also in the same town of Smallville. But the difficulty for people like Nigel and Roy, if they are operating in a fairly geographically contained area, and the potential, the person who, the defendant in the passing off action is operating, a fair distance away, it may well be that you can't actually prove enough of a reputation to extend over that geographic location where the defendant's located. So this can be quite a problematic element to prove, but we do know a few things from the facts. We know that they started using Hungry Macs when they started their business. They opened up with the name on the front of their store, plain yellow writing against a red background. And then we know as soon as they opened, crowds flooded in, business boomed, and then they applied for their trademark. And then we know here there was enough time elapsed that they had this Fred, the part-time manager, who works there for a while, gets to know the recipe sufficiently enough to then set up business across the street. And he calls his business Hungry Eat It Max. And he puts all of his knowledge that he's gained at Hungry Max to good use in his own business across the road. So in terms of reputation, we do know that as soon as Nigel and Roy opened, they were successful. Their shop was in the middle of Smallville, so I'm assuming that would be a reasonably expensive rent. There would be lots of foot traffic if it's in the centre of town. So you might be able to prove some kind of reputation from people having walked past, from the fact that they are well known and that business is booming. Also, how long have they actually been able to establish this reputation for? We don't know from the facts, but we do know that Fred has, 1, been employed, 2, worked with Nigel and Roy long enough to understand and memorise or familiarise himself with the secret recipe, with their processes, with using Roy's burger flipper, etc. He's also had enough time then to search and locate a shop directly opposite. He's been able to negotiate that lease. That takes several months of itself. He's been able to fit out the shop. He's been able to employ employees. He's been able to start trading. Now, if you add all of that up, he's going to have been there for at least a few months if he's gotten quite familiar with that business, isn't he? And so there's a few months at least to start with. He's going to, like I said, probably another month or so to locate the shop that he wanted opposite, another few months to actually negotiate that lease. It usually takes around about, well, I don't know of many shop fit-outs that happen in less than about 8 weeks. So you're looking at probably another couple of months there. Then he's going to have to hire employees and actually start trading. So he's going to also have to negotiate supply arrangements for the burger meat and the burgers and all of the different condiments that he's going to actually need in the shop. I would say that probably you're looking at about a year, I would say. Sorry, is someone saying, oh, hi, Bianca. No problems at all. So I would say you're probably looking at about a year. Now, because their business was booming right up till the end until Fred started trading, I think you could probably show a reasonable amount of reputation. But again, remember, this is all expensive court time that you're going to have to devote to this. Passing off is certainly not your first port of call, really, ideally, whenever you're trying to obtain remedies for problematic conduct by competitors. Okay, so yeah, I think there's probably sufficient reputation there, and like I said, there's not going to be any problems with Fred being an out-of-towner or anything, or that their reputation doesn't extend far enough to Fred's business because he's right across the road. Yes? So the next thing we need to show is a misrepresentation. Fred has used the sign hungry, eat Max. Now, it could be that his sign is much like that one that I saw down at Tugan, you know, where it's got like hungry, then in tiny little letters, eat at, and then in their case it was Jack's on the end. So they're really trying to emphasise the hungry and Jack's to make, you know, almost sure that at least somebody's going to be deceived into thinking that they were Hungry Jacks. Or he could have just used ordinary writing, not emphasising the hungry and the Max. We don't know. So you probably would need, I'll just put probably would need more information. And I think this is what we concluded when we actually were doing the week, the passing off week before the break. So to conclusively state whether there's been a misrepresentation. However, I think you can probably conclude a few things from the surrounding facts. And this is what we're left with. A, he has chosen a name that is very similar to Nigel and Roy's name. Okay. B, in same colours, although you couldn't put too much emphasis on this because both Hungry Jack's and Macca's signs are also red and yellow. So you could almost say the colours red and yellow are kind of generic to fast food operators in a way. I don't know that you could put too much weight on that. However, this is where it gets interesting. He chose a shop right opposite Nigel and Roy's shop. Yes, and he chose to make his fast food also burgers, the same as Nigel and Roy. So you'd be trying to stitch up a circumstantial case there, saying, well, all of this leads up to show that Fred was making a misrepresentation designed to deceive customers. Yes, much like the little mum and dad shop that I saw down at Tugan. Although I would suspect that, you know, as soon as you got inside, you'd probably know that it wasn't Hungry Jack's. And the last element that you need to show, anyone got that for me? Starts with an L.
Loss or damage?
Yes. Loss or damage, or the likelihood. Now, what do we know about loss or damage? Have Nigel and Roy suffered loss or damage from Fred's conduct? Let's see. There we go. Business immediately impacted because his burgers were cheaper. So I would suspect if people were going to Fred's burger shop, they probably thought, oh, great, we're getting a Nigel and Roy burger, we're just getting it cheaper, you know. So, yes, Nigel and Roy's profits were immediately impacted after Fred commenced trading. Okay, remedies. Main remedy for passing off is, but you can also get damages or an account of profits. Interestingly here, what would you shoot for in terms of damages or account of profits? What's the difference between damages and an account of profits? Anyone dust off the old grey matter?
Damages is sort of more like one form of it, I guess, compensation, whereas an account of profits is basically the difference that you have ungainfully gained. Might be, I'm trying to search for the word, it's a bit fault at the moment, but that's sort of something similar. So account of profits would be the profit that was made on the back of someone else's hard work, in other words.
Exactly. Yep, exactly. Damages are what you've lost. Account of profits are what they've wrongfully made. Yes. Was it, Joselito was just saying, was it because Fred's burger is cheaper or Fred deceived the customers or both? It's the deception of the customers that's important. Yep. Okay, so we can get an injunction, so we certainly want to stop Fred from continuing to trade right opposite, especially since it seems to be impacting on their business quite heavily. And we might go for whatever we've lost, whatever Fred has made. Just delete that. Misleading or deceptive conduct. What, just out of interest, who can tell me the advantage of filing proceedings in terms of misleading or deceptive conduct rather than for passing off? The main advantage here for Nigel and Roy.
I'm going to say that misleading and deceptive conduct is aimed at an actual person.
Yes.
Like a specific person, rather than passing off could be aimed at a company or something. No?
Actually, the reference to person in the Australian competition law can actually mean, and that's interesting that you brought that up, can actually mean a company or a natural person. The main thing, and if I wig out here at some point, don't worry, it's just telling me my internet connection's unstable. The big thing that you have to spend court time here with the action for passing off is reputation, okay? It's a pain and you've got to go through the factual circumstances. You've got to try and adduce enough evidence to convince the court that you actually have a strong enough reputation to have something valuable to protect here. And as you can see, you know, even just with the facts that we've got, these things do take time. Bear in mind, you're going to have to be paying a barrister about $8,000 a day to establish your reputation. So that's the really painful thing about the action for passing off. In terms of misleading or deceptive conduct, the beauty of this is that, yes, we do need to ultimately prove that the conduct was misleading or deceptive. So you're going to have to show, you know, that consumers were confused about something and that something's going to relate to your reputation. But it's not an element of the action. It's more something that you would deal with in the course of your pleadings. So really, your only elements here are, it's a person. Well, Fred is a person. Must not in trade or commerce. Is Fred operating in trade or commerce? Yes. Yes, Fred is trading opposite their shop. And is he engaging in conduct that's misleading or deceptive or likely to mislead or deceive? Well, we've said up there in the previous discussion for passing off, probably, yes, depending on how his sign was configured. And certainly, I mean, he's placed his shop right opposite. He's selling the same food. It seems that there would be misleading conduct here. Where you are alleging that someone is engaging in misleading or deceptive conduct, also under Section 18, if you can show actual deception or that a customer was misled, this evidence is gold. Yep. If you can show that you've got some people, a couple of customers that had come into your shop perhaps after having been into Fred's shop and worked out that it's not the original Nigel and Roy's Hungry Macs, you know, a court will say, well, if you've got actual evidence of a customer being misled, there's a fair inference that a misleading statement or misleading conduct was going on. And also from the circumstances, especially that he set up shop directly opposite, selling the same menu with very similar name. We've got an intent to deceive. A court will infer deception. Yep. So there's your elements of your action for Section 18 of the Australian Consumer Law. Remedies, note here, you can't get any exemplary damages here. Okay, in a lot of the other questions for tonight, you know, like for trademark infringement, copyright infringement, patent infringement, you can get exemplary or additional damages. You certainly can't under the Australian Consumer Law. Okay, so you need to bear that in mind. And that's another good reason why, if you're ever looking at the issue of trademarks, it's always better to just pay the few $1,000s to get your trademark registered in the first place, and then all of these problems disappear. I mean, you can throw an action for passing off or misleading or deceptive conduct into the mix if you're going to bother to sue someone for trademark infringement, but it's just much easier to sue for trademark infringement, and you can also get additional damages for trademark infringement, and you don't have to worry about proving reputation and all of these sticky points that we've just been talking about. Okay, so what are the remedies that you're going to be looking at under the ACL? Anyone got any ideas?
What?
Section 232 is the section that talks about injunctions, and they are injunctions for infringements of Chapter 2 offences, so that would include Section 18. Okay. Also, Section 236 is damages. Or we have Section 246. Now, 246 are my fave. These include, and I'll take you over to it because it's pretty funky what you can get. Okay, so we'll go here, just go down a bit. 246, non-punitive orders. Okay, if you've contravened Chapter 2, so that would include Section 18, misleading or deceptive conduct. It would also include Section 29, which is suggesting that your product has a sponsorship or affiliation with someone else. Yes. So, court may make the following orders in relation to the person who has engaged in the conduct. All of these different orders that you can get. Including things like an advertisement, yes, to correct the misleading conduct that's gone on. I just saw here, this says on application of the regulator. So there was also one, see here it says on application of the regulator. There was, under the old Trade Practices Act, non-punitive orders that were available on application of the plaintiff in an action under the old Section 52. Here, it seems to be on application of the regulator, which would seem to be the ACCC. If anyone can find me the equivalent of the old Section 82 of the Trade Practices Act, where non-punitive orders are available on application of the plaintiff, can you let me know? They're there somewhere. I just can't put my eye on them at the moment. Anyway, if I have any bright ideas on that, I'll post up something in the forum for you just to let you know what section that is. But there's certainly orders that are about, oh, has someone found it for me? 86.
I think it might be 86.
Let's have a look. Let's have a look. Where are they? Sorry if this is making you feel seasick. Okay, let's have a look. Used to be old Section 82. I'm still travelling under the old Trade Practices Act. Okay, let's see, 86. 86. 1C? What did you say? 86C.
86C. I can post the link in the chat box.
Oh, great. Okay. Yeah, that sounds good. Let's go. All right. Let's see if I can. Is it opening it? Let's see if I can get it in there. There we go. There we go. Oh, beautiful. There we go. On application by the Commission again. Make one or more of the orders mentioned in subsection 2 on order of the DPP, on application of the DPP. We'll find it. We'll find it. Like I said, if we don't, high five for this, exactly. If we don't do it by the end of the Zoom tonight, I'll post up, I'll find it for you and just post it up. But certainly under the old Trade Practices Act, there were a whole heap of non-punitive orders that could be made. And they were quite useful because they enabled the court to formulate a very tailored response to exactly the kind of conduct that had gone on, much more so than just a general, injunction or a general, order for damages or whatever. So, yeah, that's the thing with the Competition and Consumer Act. You don't have to worry about proving your reputation, so that's a rather good thing. And you can get a whole host of other orders there. Now, I'll just take that out there and I'll put non-punitive orders and then I'll just put here to be advised. Okay, so misleading or deceptive conduct. If Mary sued Nigel and Roy for copyright infringement, what remedy would she seek or what could she do? Would she succeed? Okay. What work are we looking at here? Someone's got something to say. Yes. We'll get to the bottom of that one. Don't worry. I'll look for you. Okay, so what work are we looking at? Now, Mary created 2 works, didn't she? One was the drawing of the winking man, and the other one was the slogan, the 11 secret herbs and spices make our burgers KFC. Someone said the other week that confused them horribly. I'm rather glad because this was meant to. They were meant to be deliberately borrowing from pretty much everybody, including, KFC, McDonald's, Hungry Jack's. So Mary's got these 2 works. Now, we need to figure out whether both of those would be protected by copyright. If you think back to the Zoom session we had in very, very early in term, the artistic work would be protected by copyright. It's an artistic work. It's an original drawing. There's no problems there. It's sufficiently original. The only difference is with the slogan, whether it would be original, sufficiently original. And here you have to look at the Sullivan and F&H case. And that was the case, remember, where that the journalists were seeking copyright protection for a heading for an article that said something like the resort that offers precious little. And they said, no, sorry, no copyright protection there, not sufficiently original. That's the kind of thing you would say in everyday parlance, and we can't be fencing off little bits of the English language like that. If it's something common and commonly used and there's no spark of creativity, then you're not going to have copyright protection surrounding it. The question is whether the addition of compare, we've got the addition of, cool for chewing. Does the word cool misspelt lend originality? I think we had a discussion around that in seems to be fairly original. Yeah, exactly. Cool for chewing is the thing that I think would probably tip it over if they could get it. 11 secret herbs and spices, no. Direct rip-off of KFC. So there's a query around the slogan, but definitely she could get copyright protection for the artistic work. Then if we flip over to section 31 of the Copyright Act, up here, we'll just have a quick look at the actual rights. So where we've got an artistic work, like the winking man, you can't reproduce in a material form, publish the work, or communicate it to the public. Okay, so that's section 31(1)(b). So you'd be looking at section 31(1)(b), and you can't reproduce, communicate to public, or publish. So what have Nigel and Roy done? They have used the winking man, haven't they, on the menus. They've distributed the menus in the restaurant, and they were seen by the public. They may have also used, the winking man perhaps on the illuminated menu in the checkout area. They may have used on napkins, who knows? But all of this will be a reproduction and a publication. Yep, So they will have contravened one of Mary's rights in section 31. We can delete that. They have to, what's the test? Can anyone remember? You have to have used a whole or a something part.
Substantial.
Thank you, Jessica. Had they used the whole? Yes. Whole drawing. So they're not going to get out of it there. Autodesk and Dyson says that you have to have used the essential features of the work. Well, they've used everything, so there's no relief there for Nigel and Roy on that front. What remedy is she going to be seeking? Well, to stop Nigel and Roy using. However, remembering always that it costs an absolute squillion to launch infringement proceedings pretty much across the board. It doesn't really matter what IP right you're suing on. Practical alternative would be what? And we did talk about this in the trademarks week. What could she do to, someone saying something to me, what could she do? Damages? Well, she would certainly seek damages from them if they continued to use without her authorisation. She would simply throw a spanner in the works with their trademark application. She would oppose their application as they don't own the trademark or sign that they're applying for. So she could certainly throw a spanner in the works there. Going to be much less expensive for her to do that than it would be for her to actually go ahead and sue for copyright infringement. Usually what will happen is you'll chuck in a cease and desist letter first off. You'll say, hang on a minute, our client owns copyright, your client's infringing, your client doesn't own what it's using, and we're going to oppose your, settlement. We're going to oppose your trademark application. Yes, and Joselito has very sensibly said the practical alternative for everyone is she should just ask for whatever, she thinks is a fair thing. Joselito, yeah, that's exactly right, settlement, dollars. It can be anywhere, depending on the value of the thing, it could be anywhere from 5 to, oh gosh, you could do 50. I don't think she'd get $50,000 out of them. I think she might get somewhere between 5 and 20. So that's probably where that would go. If Macca's or Hungry Jack's threatened to sue Nigel or Roy for trademark infringement, what remedy would Nigel and Roy seek? What remedy? The big boys are breathing down your neck. They're saying, we have these awesome suites of trademarks. You're infringing under Section 120 of the Trademarks Act. Please stop it immediately, or we'll come down and do very nasty things to you that will stop you from. Joselitos is not identical. Yes, and I'll get to that in just a minute, Joselito. Trademark, so they've threatened to sue, but they haven't actually sued. So your first port of call there, if you really thought things were going to get difficult, would be maybe Section 129, unjustified threats of infringement. Now note, You can only seek this if this is only available if trademark infringement proceedings have not been filed. Yep. Because you're saying they're unjustifiably threatening us. It's not fair. There's no real prospect of them succeeding, and therefore we are seeking this remedy. Let me just take you to the provision 129. There we go. Groundless threats. If a person threatens to bring an action, which is exactly what Macca's and Hungry Jack's have done here, haven't they, against another person on the ground that the threatened person has infringed a registered trademark or alleged to be registered, any person aggrieved can bring an action against the person making the threat. Purpose of the action is to obtain from the court declaration that there's no grounds, injunction restraining the defendant from continuing to make the threat. So it's kind of like calling their bluff in a way. You know, either you put up or, as the saying goes, you shut up. Either you file your proceedings or you don't. You leave us alone, okay? So they certainly can seek that remedy there under 129, groundless threats and infringement. The difficulties with, there's no real difficulties for, here, I'll put difficulties down 1. All right. The difficulties the difficulty is the main way that Macca's and Hungry Jack's can clear up this little problem under Section 129. They just need to file an action for infringement. Then 129 goes away. Yes? It might be more effective against somebody that was less likely to sue. It's really not going to be any skin off of Macca's or Hungry Jack's nose to file an action for infringement, because they spend hundreds of thousands, if not millions, a year, certainly millions globally, I'm not sure about Australia-wide, in suing on these things. So, you know, it's not going to be any problem to just file an action for them. So if you did go the 129 route, you might get stung in the tail at the end because you probably have just provoked Hungry Jack's and Macca's into actually filing against you for infringement. So they would see above. They just file application for an action. Okay. I guess as Joselito was saying before, how easy or difficult it will be for Hungry Jack's or Macca's to sue for infringement will depend on what the sign looks like. Under Section 120, we know that it has to be, what's the test for trademark infringement? Substantially yes. So we need to find out what Nigel and Roy's sign looked like. They chose the name Hungry Macs, sorry. Externally, they didn't use any stylized writing or logos. We don't know if it was in uppercase, whether it was in lowercase. We don't know what the appearance was, so that makes it a little bit difficult to say whether it's going to be confused with something like the Golden Arches or something like, you know, the Hungry Jack's registered mark. Plain yellow writing against a red background is all that we really know there. So you're going to have to look at, was the sign really substantially identical or deceptively similar to Macca's sign or the Hungry Jack's sign? That will really, you know, influence your decision about how you're going to go on this. Would they succeed? Well, that's going to depend on, like I said, the similarity of the sign, like Joselito said. So that's your suite of trademark-related issues there. The last little thing that I've thrown into the problem is if Roy, who, remember, he invented this burger flipper, wanted to sue Fred for patent infringement, there's an immediate problem here. What is the immediate problem? Can anybody tell me? I'll flip back to the facts for a moment.
I don't think Roy actually has a patent, does he?
No, thank you, Bianca. He does not. Roy had developed a burger flipper tool, had applied for a standard patent. He's applied his complete specification. So all he has at this point is a patent. He just has the rights of an applicant. He does not have the rights of an actual patentee. And if you have a look at Section 120 of the Patents Act, let me just skip over here. Section 120. Yeah. Infringement proceedings may be started in a court or other court jurisdiction by the patentee or exclusive licensee. So at this point, he can't threaten patent infringement, or if he does, certainly there is an action for unjustified threats under Section 128. So if he did threaten Fred with this, Fred would just simply ask the court for relief. Yes? So Section 128, now let me just put that down here. Oops. Okay, what would Fred do? He would seek relief from unjustified threat of infringement. Okay, all that Roy has is just the application at this point. So I took you to Section 120 there that just says the patentee is the only one, or the exclusive licensee. It's the only one that can sue. Would he succeed? No. All he has is an application. Now, if a patent were granted, would he be successful? If Roy sued Fred for infringement, what is the immediate thing that Fred would do to knock out this infringement action? Patent Infringement Strategy 101. I think I did mention this in the Patents Week. You get sued for infringement? Hey, I got a taker here. Yes, exactly, Joselito. Why is it not typing here? Okay, Fred would allege Roy's invention was not inventive. That is, no inventive step. What is the fact, the snippet in the facts that makes you think that Fred would probably shoot down Roy's patent if it was ever granted? Can you tell me?
The fact that he easily replicated it.
Yes, thank you, Jessica. Fred say the flipper could be easily replicated. And remember, if it was obvious to a person skilled in the art, then not inventive. Yes? So the moment he goes and sues anybody on this, he will more than likely get that patent shot down. If there was no patent, we've already looked at that. Remedy, well, what can Roy do about Fred's use of this burger flipper? Anything? Not really. He can make nasty noise.
I don't think so, no.
No, he can't really. I mean, there's nothing really that you could say about this, except perhaps you might use it as grist for the mill when you were trying to argue, you know, your things like misleading or deceptive conduct and passing off. I mean, this is just one more thing that Fred has used in setting up his business that shows that he really does want to replicate the kinds of burgers that Nigel and Roy are making, yes? And by setting up across the street with pretty much almost the same name, using the things, the implements that Nigel and Roy use so that your patties stay all nice together and they don't break up in the cooking process. And he obviously wants his product to look like Nigel and Roy's product. So this would just be one other thing that you'd throw in the mix in terms of, you know, a misrepresentation or proving that there was misleading or deceptive conduct. I think I can't see any other recourse for Roy at this stage. What should he have applied for, really, for this burger flipper?
An innovation patent.
Thank you, Jessica. That is because for innovation patents, it doesn't really matter if the what they call innovative step rather than inventive step, to make it very clear that you're not looking at that high level of inventiveness that you would for a standard patent. Anything that makes an implement work a little bit better, you'll more than likely get an innovation patent for it. You're going to have to get examination done ASAP, because remember, even though you can get a grant of an innovation patent without examination, you can't sue on the innovation patent without that examination having been done. So you'd have to get the examination done. But these things can all happen quite quickly. So that's what he should have applied for, okay? Commercial thinking, pretty much with all of them. What would you try and do with Fred? Just tying this up as we come to a conclusion here. If you're not going to get into the nuts and bolts of a passing off action or a misleading or deceptive conduct action against Fred, or you're not going to be suing him perhaps for breach of confidence for using their procedures manual, what do you think you might be talking about with, let's have a look, what are we saying, Bianca? Yes, settlement. And this is pretty much, you know, for most of these, the answer is pretty much the same. Settlement. You would be looking at negotiating with Fred. You'd say, look, you've only been operating here for a matter of, you know, days, weeks, months. You haven't got a whole lot tied up in this. What will it take to make you go away? Obviously, it's taken you time to set up your business. It's taken you, you've got to have contracts of employment. You may not. You're going to have to break those. You're going to have to break your lease. You're going to have to sell off your plant and equipment at fire sale prices. We'll cover off all of those costs and we'll give you a lump sum of X if you'll go away. All of that, even though it sounds, you know, like a relatively high amount, it's going to be cheaper than suing, let me tell you. So you would try to make it work with Fred if you could. Alternatively, what about that saying, keep your friends close and your enemies closer? What's the other tactic you could take with Fred? I don't know, this would probably be a bit of a gamble, but you could offer Fred employment again, perhaps partnership in the business, perhaps for limited time. Yes, these are all options that you'd probably want to throw out on the table for your client. In terms of Mary, definitely settlement would be the way to go. And like I said, I think you'd probably get her out of the picture from, say, 5 to 25,000. I think, you know. Hungry Jackson McDonald's here. Now, they are going to be looking at suing you for trademark infringement. And there's, depending on how similar, you know, Nigel and Roy's sign was, they probably would stand a reasonable chance at succeeding. So what are the options here for Nigel and Roy? What kinds of negotiations would they be having with Hungry Jack's or McDonald's? Their first option? Yes. If they're not that wedded to it, they could offer to stop trading under that mark. This would depend on how long they'd been trading and how wedded they were to the mark itself, how much reputation they'd gathered in the mark. If they'd been trading for a couple of years and they were, you know, their business had a fairly decent turnover, okay, bye Bianca. Yeah, it just would depend. You know, if they gathered a fair bit of reputation, they might not want to offer to stop trading. If they'd only been trading for a relatively short while, even though they had been very successful, you know, they might say, oh, okay, we'll stop trading. We'll trade under something different. And, you know, sometimes when you have a mark that changes, you know, you can advertise the fact that, you know, you haven't changed, the owners are still the same, the recipe's still the same, it's just the name that's changed. So you know, hopefully educate the public to the fact that you're changing your name. Or their only really other option would be to fight on, spend the money and hope that Hungry Jack's and McDonald's won't win. That's got to be a black hole and it may carry on for some years. It all takes a fairly large psychological toll when you're running an action like that. So really, these would be very practical things that Nigel and Roy would have to be sizing up to work out what they should be doing to respond to Hungry Jack's and Macca's. It's very difficult when they misspell everything. Nice work, Joselito. That's what I like. Sign of a good IP lawyer. Fred's used the verdict. Well, there's nothing that they can do there. Is that all good with everybody? Does anyone have any queries, questions? All sound relatively sensible. Okay. Well, thank you very much, ladies and gents, for coming. I appreciate you coming at this time of great assignment need. I hope everything goes okay for your assignments. And I'll put this recording up, as I said, to replace the other one that I did last week. And apart from that, thank you very much for coming. I'll see you next week. Joselito, did you have a query? Oh, good. Awesome. Thanks, guys. Okay, I'll see you next week.